right, welcome back. It's almost over. Last capsule on interests in land, and then the chapter's over. And fortunately, lots of the things that we'll look at this week are a lot less important than the stuff that we learned in the past 2 weeks. Certainly still important, right? But the Statute of Uses and the rule against perpetuities isn't all that important for our purposes as long as you manage to understand the basics of it. So first thing that we have in this chapter are the rules regarding common law remainder. So that's something that we alluded to quite a bit earlier, right? We said there are rules as to uncertainty, which we also call contingency. That's essentially what we look at this week. So the remainder rules first apply to a remainder that's vested to a third party, and only by virtue of the original instrument. So they only apply when you have, say, right, you grant an estate to A and then the remainder to a third party. So if it's not a third party, it's the grantor, in which case it's a reversion, not a remainder, then they don't apply. And if the grantor subsequently transfers their right of reversion, it also doesn't apply. It has to happen in the first instrument there. And essentially what they were trying to avoid, right, without getting into all the history of it, is to have an overly long period of uncertainty, right? So say you have the right to re-enter upon the happening of a specific event, right? So it says, if the person conceives illegitimate children, I may re-enter, right? Then you have uncertainty as to how long it will take, and you also have uncertainty as to whether that right will be exercised, because you'll recall then that is a defeasible estate, right? And a defeasible estate means that the right is not exercised automatically. So upon the happening of the event, right, the interest isn't directly transferred. The person has to do something to specifically exercise their right, and for it to therefore be transferred. And that has to happen. And so you have further uncertainty as to how long they'll take before they decide to do that, right? And they might, in fact, never decide to do it. So the first rule is, right, it is void unless when created supported by a particular freehold estate. So it's something that we alluded to earlier, but that we didn't specifically mention, right? But there has to be a freehold estate that's created, and it has to be present. So you can say, right, to A for life, then to B for life, and then whatever it is after that, right? That's allowed. And one of these interests can be contingent. So you can say remainder to C, right? And that can be contingent. So you could say remainder to the first child of C, and C might not have children at the time. And that's fine. The remainder is contingent. We said it's fine, right? It's neither vested in interest nor possession. There's uncertainty, but you're allowed to have that. And then at some point, right, the interest will vest, namely when the life estate ends. However, you can only have that uncertainty, in that case as to the person who gets it, for the remainder interest. The main estate cannot be uncertain and cannot be future, right? So you can't say to A for life 10 years from now, for example. That's just not allowed. That's a future transfer, and you're not allowed to have that. So there has to be, right, the main part of it that is present, right, and that is that's essentially transferred immediately, and therefore has to be certain. Then the second rule is a remainder after a fee simple is void, which is kind of obvious actually. So you cannot give more than you have. That's something that we saw under multiple previous concepts, right? So if you give to B in fee simple as the grantor, you obviously can't give a remainder, right, to a third party because you don't have one. As the grantor, you gave everything you have. It's your fee simple. Therefore, you have nothing else to give. However, it also applies to conditional estates, which we oversimplified by lying a little bit before. So if you have a defeasible or determinable estate, so it says, right, if she does that, I may re-enter, or it says, when she does that, I may re-enter, right? These were the two examples. That's what the distinction in the wording there is what differentiates a defeasible from a determinable estate. The reality is that cannot be done by a third party. In most of the examples we saw, it wasn't, right? But that's actually a feature of it. So that is allowed, right? Even though it's attached to a fee simple. So you can say you're granting it in fee simple, but if the person does something, right, I may re-enter. And that cannot be given to a third party. That's why it would be called a remainder. So it can only be exercised by the grantor. So you can't say if she conceives or when she conceives illegitimate children, right? C may re-enter. Some third party can only be the person, and that's by virtue of rule number 2. Then you have rule number 3, which is not really relevant for our purposes. It's essentially, and that rule you can essentially forget about, right? But it's essentially about an interest that otherwise would have gone for the entire period. So if you have a life estate, and then you allow, say, right, a third party to exercise a condition, that's not allowed. And that's essentially a permutation of what I just said, right? Because if it were allowed, right, it would be a third party who would be exercising a right of reversion or reentry, right? And that would not be allowed. Then you have rule number 4, which is that the interest has to actually vest within the period for which it's provided. So the example you have there is, I'm at page 284, right? 2R for life, remainder 2S and or heirs upon marriage. So essentially, it's a result of things that we already saw. When you have a period that is provided for, it has to actually vest during that period. So if it's the R for life, right, then you can have periodical uncertainty until the end of that life estate. So that's what I said at the very beginning under Rule 1, right? You cannot have uncertainty as to who has the life estate, because then it's not a present transfer, and that's the main estate that you're granting under Rule 1, which has to be present, right? However, the remainder, the rest of the interest, can be contingent. So it can be granted to people who either aren't identified yet, although they might be alive, or simply aren't alive yet, right? Don't exist yet. However, for the interest to vest, right, you have to actually be able to identify these people by the relevant time period. So if it says to A for life, right, remainder to a group of people who aren't identified yet, right, or a single person who isn't identified yet. At the end of A's life, to the extent that you still cannot identify them, the contingency fails. So it can be contingent until it's determined. At the time of its determination, if it can't be determined, you can't identify the people, then it fails, right? The contingency is over because it can't last forever, and it would go back to the grantor, although legally the grantor hasn't specifically retained anything. That's how the rule operates. And as is mentioned on the same page, right, this is actually of very little relevance today because most of the time you have trust documents that will avoid these specific issues, and that also provide for a lot more flexibility in the way in which you can design successive interests or interests which are held for third parties or held in part. Then there's a discussion as to equity generally, not all that relevant for our purposes. As we briefly discussed earlier, right, was essentially an alternate system where you had the actual common law court, where the actual common law judges would make decisions, right? And then you showed up there, they had to apply whatever rules they had by virtue of prior cases. If you weren't happy, right, historically, you could call up the king for discretionary relief because the king had the power that was vested upon the courts to start with, and therefore you could call up the king and say, I want discretionary relief. And the king could say, right, I will ignore the law and give you whatever you want, often because it seemed to be fair, right, or the opposite of it seemed to be unfair. That eventually was institutionalized because you had so many people asking the king for relief that it was systematized and eventually became a different court system, which we called equity, and where essentially the purpose was, right, to go and ask for stuff that you weren't entitled in law because you thought it was unfair. And there, right, the rules were more relaxed, the power was more discretionary, and the rules of procedure, right, were not all that important as opposed to the actual substance of what you were claiming and its impact upon you. That's where the trust structure was created as what is described in a pretty long-winded way there, the use, right? And then you have all the bad French again coming up, which somehow they decided French was better than Latin, but they couldn't spell it right. Nonetheless, that's what you have, right? The use structure where essentially someone had the legal title. That's the important part, right? So you transferred legal title as you otherwise would. So if you're giving someone a life estate and then a remainder to a third party, you're transferring legal title, right? You're transferring your property right, your title, and you're splitting it up. So you have the rights, right? And then you split them up into two people, and you're nonetheless transferring each a property right. And that's part of your title. In a trust structure, in a use structure, you still did that, right? So you still had a title transfer to a specific person, but that person did not have use of the property, right? Not in the sense of a non-possessory interest like a life estate. They just didn't have use of the property at all, ever, and that was a third party who did. So they had it for the use of a third party, which is essentially the preliminary version of a trust structure. You have the description there, page 289, which we won't go into in that much detail. But essentially what it did is that it got away from the rules that were problematic. So when you had some prohibited interests that we just described, because they were contingent for an overly long period of time and therefore invalidated, when they were created by using a trust structure, a use structure, you got away from the rules because someone retained the interest. So, and we won't get into all the specifics of that because it's complicated enough already, and the stuff from the previous 2 weeks is a lot more important, right? But essentially, right, things you weren't allowed to do. So say you grant to A 10 years from now that otherwise wouldn't be allowed, because of Rule 1, right, because you're creating a gap there and you're not allowed to do that on the principal estate. If you have a use structure, someone else has the title, so you're granting it to A for A for the use of B 10 years from now, for example. Then you solve the problem, because for the 10 years before that, A has legal title anyway, and so there's no gap in title, even though the end result is the exact same, right? Because A has title, but it's essentially worthless because they do nothing with it. It's only for the benefit of a third party, the entire thing, right? Not just use, the entire thing. So it also means revenue often and all that, right? But because you're avoiding the gap or the uncertainty that's otherwise prohibited in law, then, right, the trust structure essentially prevents the application of the typical common law rules that otherwise would prevent that. Then you have, and again, we'll keep that, we'll keep looking at that summarily because I think it's complicated enough already. Then you have the Statute of Uses, which is when the king woke up and decided it wanted this whole thing to end. Essentially was, right, a bunch of smart lawyers or whatever they were called at the time who came up with these use structure to get away from, again, the various feudal obligations that defrauded some very important people to the king who just sat on their butts and collected money from other people, from other people's work. So the king woke up, thought, right, that's not really cool. So what did the king say? He said, to the extent that you grant something in trust, so in use, so you grant it, right, to A for the use of B, the Statute of Uses, and again, we're just looking at the basics of it, that's plenty, will nullify that. It will make it as if it never happened, and therefore as if actual legal title was transferred. So you're trying to get away from giving it to B by saying you'll give it to A for the use of B. Statute of Uses nullifies that and effects actual transfer to B, right? In fact, does that after a brief imaginary period of time, which can, in some limited circumstances we won't look at, have an impact. So the actual conceptual reality of it is that, right, it nullifies it just slightly after it happens, after it's been created. So it does go to A for the use of B, and then immediately the title gets transferred immediately. Slightly after, the title gets transferred directly to B. It's as though it never happened. Right? So it's as though you hand transferred it to B directly, which is the thing you were trying to get away from by affecting a use structure in the first place. There are a bunch of exceptions which we won't look at, right? These exceptions are first to create a leasehold estate, because of course all these rules apply to freehold estates, right? Life estate's freehold estate, fee simple is a freehold estate. A leasehold estate is entirely different, and none of the rules as to, right, of course, the remainders and all the names apply to a leasehold estate. Then you have an exception as to corporations, which are not covered. It's this natural person, so physical, actual people. Third, more importantly, when it was not a passive structure, so when you had a reason to grant it to A for the use of B, in that A actually did something there. It wasn't just to defraud the baron there, right? Then the Statute of Uses did not apply. Then, as you have, page 293 and following, the lawyers got smart. They got even more complex language, and they figured out a way to get away from the statute entirely. Again, the important stuff on the Statute of Uses is what I just said. Then you have a further exception, which we will, again, briefly mention but not get into because it's plenty already, right, which further complexifies that. So we said the use structure gets away from the strictures of the common law remainder rules because it creates it has a third party who can, in the meantime, prevent what you're trying not to have. So if you, what we call springing and shifting interest, right? If you're trying not to have the 10-year period where you have to wait, when you're not allowed to wait, you have a use structure, someone has legal title as of day one, they can wait for the 10 years and be the right placeholder in the meantime doing nothing, and therefore, right, the transfer does not fail at the beginning as it otherwise would pursuant to the remainder rules. The statute of uses, right, will, as I just said, cancel that, right? It will cancel the conception that you just created. So if you grant to A for the use of B in some more complex way maybe, right? All that to get away from the stricture of the common law remainder rules. The statute of uses will make that as though it did not happen, right? But really by nullifying it after the fact. So it will allow you to do that and then right after transfer the actual title to B. And it will be as though you granted it to B, but not really because you had the statute of uses apply. And the statute of uses makes it so that, and we're oversimplifying things, and it's plenty that way again, right, will get you away from the common law remainder rules. So one of the ways in which you can get away from the common law remainder rules is by creating an equitable interest. You grant to A for the use of B, or some other permutation of that, right, which would be prohibited by the rule. If you do that under the equitable structure, the trust structure, the rules don't apply because it's not a legal interest, it is an equitable interest. The statute of uses nullifies your trust structure. So you create an equitable interest, but then the statute of uses comes in and makes it as though the transfer, right, were done directly to B. Nonetheless, you still get away from the remainder rules. That's the important stuff there, because it remains essentially an equitable interest, right, which becomes called a legal executory interest, which is not the same as the legal interest you would otherwise have had under the common law rules. So the statute of uses applies, right? It does not remain an equitable interest. It's transformed into a legal interest because the law applied, right? Not the equitable rules. Nonetheless, it's a different type of legal interest, as if you did not have all the intervening stuff happening. If you just transfer to B, legal interest still, common law rules apply. If you do it with a trust structure, to A for the use of B, then it's an equitable interest, but then the statute, right, moves it to be as though you had transferred it directly to B. It becomes a legal interest again, but one of a different kind. And so even though the statute of uses nullifies after the fact your trust/equitable structure, that, right, doesn't mean it's as though it never happened, right? Therefore, it's a legal interest of a different kind, and the end result is the same in that B gets the title as though it were transferred directly, but because you went through all these steps, the common law remainder rules don't apply. That's the important part. Okay, then the rule in Purefoy and Rogers is, to the extent that an interest to which this magic happens could have, and that's the operative part, not did, but could have. If it did for sure, the whole thing doesn't need to apply. It doesn't make a difference. If it could have complied, then the rule will apply. And we won't get into its application all that much because it's already complicated enough, but that's essentially what you have to remember. So the trust structure, even with the statute of uses, gets you away from the common law remainder rules to the extent that you would not have complied. So my example in you transferred it 10 years from now. That's a direct, blatant violation of rule number 1, and therefore it's invalid. It's void ab initio. It's just not valid. It was never a thing to start with, because the main transfer which you're relying on is itself invalid because it's in violation of Rule 1. If you do that with a trust structure, even with the statute of uses, it's okay, because the rule doesn't apply. Rule in Purfoy and Rogers is when you're in between. When you have something that might be a violation of a rule, but you don't know yet. So for example, it requires you to wait for a period of time. That's allowed, but then it will fail. And you don't know if it will. Then the statute of uses doesn't help you, because it wasn't for sure in violation of one of the 4 rules. It will be considered a legal interest, and the benefit of the statute of uses will not apply. It's the only thing you have to remember about that. Okay, then there's a discussion of a trust, right? More generally, I'm at page 297 now, which is something that we looked at earlier, right? You'll recall my example with irresponsible kid. I said, you give the stuff, right? You have $5 million. You want to give that to your kid, right? Because you die. But you don't want the kid to take the money and buy Ferraris with it. So what do? You give it to a third party, right? Trustee, responsible person. And then a responsible person will be responsible for giving the kid, right, as much as the money as they need to buy food, but not Ferraris. That's a trust structure. You give it to a third party, and the third party administers it for the benefit of the kid. Again, same thing as the use structure. That's why it's where it comes from, right? The benefit of that is that, right, you are giving the benefit of the money to the kid, but not the responsibilities which are vested in a third party. The legal corollary of that is that the legal title is vested upon the person who manages it, right? In the real world, generally, you'll have a company, and a company will have, right, or some other corporate entity or business organization will have the actual title. Let's say it's a person, right, in the traditional sense, and that person has legal title, actual legal title. So even though they only hold it for the benefit of a third party, legally they are the person who has title. So they'll show up in the registry as the owner. Although, first important thing, the title is separate from the rest of their stuff, right? So of course, because it's a different kind of holding, because they don't hold it for themselves, they hold it for a third party. If, right, someone tries to seize their stuff, they can't seize that, right? Because it's different kind of stuff that they hold. They don't hold it for their own benefit. And the irresponsible kid still has some interest, some legal interest, which we call an equitable interest in the property, which is to either get the income, and usually, right, the trust structure won't last forever. They'll have an eventual interest to get the actual money. And that interest allows them to do certain things that we saw earlier in some other contexts, like the law of waste, which is to sue, right? Even though they don't have the property, they don't own the property. They have some sort of an interest. The use of that is that they can sue upon the interest, and therefore, right, get the trustee to do their job properly. So they can, if the trustee's mismanaging the money, they can sue the trustee, right, and get damages from them because they didn't do their job properly. And you have certain obligations that come out of that, which we call fiduciary duties. Fiduciary duty is an obligation to properly manage something for the benefit of someone else, right? So we'll expect you to do what a prudent parent would do, right? So we'll expect you to invest the money intelligently, not to take undue risk, right? Not to pay yourself too much out of the money, not to use it for your own benefit. And these are fiduciary duties, right? because it creates an obvious conflict of interest. When you have something yourself, right, you have a natural temptation to use it for yourself, and you can do that because you have title to it, you have control over it, right? So you could take the money, run away with it, right? Fiduciary duties prevent you from doing that and tell you essentially to only consider the interest of the third party. That's what the law says, right? If you did something that the person would not have done, it's not fully in their interest, then you can get sued for that because it's a breach of fiduciary obligations. Okay. Final thing that we look at in estates and land, again, I'm sure you're all glad this chapter is ending, is the rule against perpetuities, which again is not all that relevant for our purposes. You have to understand the broad strokes of it because it's important, right? But all the stuff that we learned for the past 2 weeks is a lot more important. So there is a limit as to how long, that's the actual limit as to how long you can have uncertainty for. So, example there. Let's say it is a defeasible estate. So, if she conceives illegitimate children, I may re-enter. That is naturally limited in time in that when she dies, she certainly won't conceive illegitimate children. She's dead. Therefore, there is no more risk that the condition will be met and that you will re-enter. Same thing generally if you die. However, you could have said, if she or her heirs conceives illegitimate children, I or my heirs may re-enter. It's not a permutation that we saw earlier because it makes things a lot more complicated. Again, not that important for our purposes. You could have said that. What does that do? It creates essentially a permanent restraint upon, right, upon the use of the property. So going forward, right, there's a limit as to what an indefinite number of successive generations can do. And that we don't like, right? We don't like because it's a restraint upon what people can do with their stuff, right? Which we saw when you do it explicitly, you can nullify as an impermissible restraint upon alienation. And we especially don't like it because it's contingent. So if it's a right of re-entry, right, again, it's not automatic. When she does conceive illegitimate children, if it's phrased as an if, it doesn't automatically go back to the grantor. The grantor has to exercise their right, has to come in and say, now it's over, you leave. If they don't do that, she retains a legal interest. It's not transferred automatically, it's transferred when they ask. So you have uncertainty there, right? You have uncertainties to whether she'll conceive illegitimate children, uncertainties to whether the grantor will exercise that. And that uncertainty you can have last forever, as in my earlier example. The courts made up a rule that says the contingency has to happen within a life in being plus 21 years. And again, just understand the broad strokes of it, that'll be plenty. It has to happen within a life in being plus 21 years. So a life in being meaning a life in being, so someone who's alive now, plus 21 years. So my earlier example would be invalid because the contingency of conceiving illegitimate children I just imposed upon an indefinite number of successive generations, right? The contingency will not be ascertained within a life in being plus 21 years. In fact, it will never be ascertained, right? It can last forever as long as people have children. And therefore, it wouldn't be allowed, right? And it would be invalidated by the rule against perpetuities. Very rarely, though, and again, just understand the broad strokes of it, very rarely, though, will the life in being be specifically mentioned but often it will be implied. So in my earlier example, right, if she conceives illegitimate children, I may re-enter. No one said there's a life in being. No one did the math. But implicitly, you can tell that if she's dead, she can't conceive illegitimate children. Therefore, it respects the rule. It's less than a life in being plus 21 years. It's just a life in being. The contingency will be ascertained when and if she dies, or when she dies. You can have multiple lives in being, then you'd have them named, right, because they can't be implicit, but you can have multiple ones. The only rule as to that is that, right, it has to be a small enough number of people such that it's not impossible to ascertain. So if the group gets too big, then it might be invalid, but there's no rule in the first place that says it has to be a single person. And again, the rule generally, right, the important thing to remember about the rule is that it has to vest within a life in being plus 21 years. Not it has to be able to vest. It has to vest. Otherwise, it's void at the time of the transfer, which is what we call void ab initio. There's a discussion of statutory reform in Ontario at page 305, which you can mostly, again, forget about. But basically, it reverses everything we just saw. But it's still helpful to know the actual common law rules on that. And the new Ontario, or somewhat new Ontario rules aren't detailed that much. First, it allows what would otherwise be prohibited in waiting. So if you have an interest that potentially would violate a rule, right, then the Ontario statute adopts the opposite approach as a common law. It allows you to wait and see, and then if it doesn't happen, right? But it allows for uncertainty that otherwise would be invalidated ab initio. And it also creates a specific, only two important things to remember. Also creates a 40-year default period when there is no life in being. So when there is no life provided for, implicitly or explicitly, then instead of the life in being plus 21 years, and only when there's none, explicitly or implicitly, there's a 40-year period that applies. Importantly, which is something that's completely made up by statute, it applies to both determinable and defeasible estates. So I just said, if it's determinable, it doesn't apply, because when it's determinable, there's no uncertainty, right? When she conceives illegitimate children, right, it's phrased as a certainty, even though it's not sure to happen. But more importantly, by virtue of the rules we saw in previous weeks, when it happens, it's automatic. It gets transferred back to grantor automatically without them exercising it. So they don't have to come in and say, hey, I want it back. It's theirs automatically. Person loses their right. Because of that, it's not contingent. Uncertain. The Ontario statute says it is, and it's 40 years. As for a defeasible interest, which itself would be contingent. So it removes the distinction between a defeasible and determinable estate for that purpose. And that will be it for Chapter 3. And we will look at something else in land going forward. So, again, all of that, the broad strokes of it, the important stuff is in the readings for the past 2 weeks.